Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, any views and opinions expressed in this podcast are those of the podcast creator alone and do not reflect or represent the views, positions, or policies of any organization, institution, or entity, past, present, or future, with which the creator is or may be affiliated.
Okay, let's unpack this.
Let's do it.
We are diving into a really major patent law ruling today. From the Federal Circuit, no less.
Oh, yeah. This one sent ripples, big ones. It fundamentally changed how people write patents and maybe more importantly, how much the public can rely on the actual claims.
Exactly. We're digging into that tension, between describing your invention fully, which you have to do, and then legally staking your claim to it. It's tricky.
It really is. In this case, Johnson Johnston Associates Inc. VRE Service Company, it really brought that conflict to a head. It forced a decision on the doctrine of equivalence, or DOE, especially around disclosed but unclaimed subject matter.
So the core question boiled down is pretty stark, isn't it?
Yeah.
If your patent describes, say, option A and option B as working solutions, but you only actually claim option A,
Right.
can you later stop someone, a competitor, from using that option B you described but didn't claim?
That's the million-dollar question the court tackled. And, spoiler alert, the en-banc Federal Circuit's answer on March 28, 2002 was basically a loud no.
Okay, let's get the specifics down first. The case name again.
Johnson Johnston Associates Inc. VRE Service Company, Inc. And the citation, for those following along, is 285 F43D 20L46,
Court.
United States Court of Appeals for the Federal Circuit, sitting on banc, meaning the full court, which signals how important they thought this was.
And the parties.
Oh.
Johnston was the patent owner.
Correct. Johnston was the plaintiff appellee, asserting their patent, U.S. patent number 5,153,050,000. You can call it the 050 patent.
Against RE Service Company, or RES?
Yep, RES, the defendant appellant. And you had some heavy hitters legally. Donald Dunner for Johnston, Frank Porcelli for RES, big patent law names.
Right. So what was the 050 patent actually about? What was the invention?
It was in the field of making printed circuit boards, those green boards inside electronics.
Okay.
The specific problem was handling very thin, fragile copper foil without damaging it. The patent solution was pretty clever. Temporarily stick the fragile copper foil onto a stronger disposable backing sheet, a substrate.
Makes sense. Easier to handle that way.
Exactly. Then you process it, and later you remove the backing.
Now, here's where the trouble started, right? The claims versus what was written in the description.
Precisely. This is the crucial part. Claim 1, the main claim, was very specific. It said the substrate, that backing sheet, had to be a sheet of aluminum. Very clear.
Only aluminum. Got it.
But then you look at the specification.
Mm-hmm.
That's the part of the patent that's supposed to teach the public how the invention works.
Yeah, the detailed description.
And in that description, it explicitly said something like, while aluminum is currently the preferred material, other metals, such as stainless steel or nickel alloys, may be used.
Ah, okay. So it named steel as an alternative.
Named it directly. It wasn't vague. It said steel could work.
So the defendant, RES, they saw that disclosure, I imagine.
You bet they did. RES started making and selling similar laminates for circuit boards, but instead of using aluminum for the substrate,
They used steel.
they used steel, one of the very materials mentioned but not claimed in Johnston's own patent.
So no literal infringement because the claim said aluminum and RES used steel.
Correct. But Johnston sued anyway, and initially they actually won. A district court jury found RES guilty of willful infringement.
How? On what basis?
Under the doctrine of equivalence, Johnston argued, look, steel does substantially the same function, providing that rigid backing in substantially the same way, to achieve the same result.
It's equivalent.
Which sounds like exactly what the DOE's for, right? To stop people from making tiny, meaningless changes to get around the exact claim wording.
That's the classic DOE argument. But here's the twist the Federal Circuit had to grapple with. Could Johnston use the DOE to recapture something, the steel substrate that they themselves disclosed in the patent text, but chose not to include in their claim?
Okay, so the fact that they knew about steel and mentioned it but didn't claim it, that was the problem. That was the heart of the legal issue. It created a conflict, or at least a perceived conflict, in the Federal Circuit's own prior rulings. You had one case, Maxwell, that seemed to say, if you disclose it but don't claim it, you've dedicated it to the public.
Dedicated means given away.
Yeah, essentially given away, put it in the public domain.
Yeah.
But then another case, YBM Magnex, seemed to soften that rule a bit, suggesting dedication only applied if the disclosed alternative was really distinct from what was claimed.
Okay, so Johnston must have leaned heavily on YBM Magnex.
They did. Their argument was basically, steel works like aluminum here. It's functionally the same. It's not that distinct. So under YBM Magnex, just mentioning it shouldn't mean we dedicated it. We should still be able to use the DOE.
And RES's argument, they went back to Maxwell.
Absolutely. RES hammered on the Maxwell principle and the whole purpose of claims. They said, look, the claims define the invention's boundaries for the public. That's their job, public notice. Johnston knew steel worked. They wrote it down, but they only claimed aluminum. The public, including RES, should be able to rely on that clear boundary. If Johnston wanted steel protected, they should have claimed it and let the patent office examine that claim.
So a clash between flexibility for the inventor versus certainty for the public?
Exactly. A fundamental tension in patent law.
All right, the moment of truth. The full Federal Circuit hears this en banc. What was the final decision? Did RES infringe?
No. The Federal Circuit reversed the district court. They held that RES did not infringe under the doctrine of equivalence.
Wow. Okay, so the dedication rule won out. Let's get into the why. What was the court's reasoning? This seems like a big deal.
It was huge. The court really emphasized the primacy of the claims. They said the claims are the sole measure of the grant. What you claim is what you get, period.
Not what you describe in the background.
Exactly. They drew a sharp line. Specifications teach. Claims claim. The specification's job is disclosure, teaching the public. The claim's job is defining the legal monopoly. And they established very clearly this dedication rule. Subject matter that you disclose in your patent specification, but do not claim, is dedicated to the public. Full stop. You can't use the DOE to claw it back later.
That seems harsh. What about inventors who just prefer one version but no others work?
The court addressed that through a policy lens. They worried about inventors gaming the system.
Gaming the system how?
Well, imagine aluminum and steel both work. You might claim only aluminum because maybe claiming steel too would invite harder questions from the patent examiner, maybe an obvious misrejection.
Strategically narrow claiming.
Right. Claim narrowly to get the patent granted easily, then later try to use the DOE and your specifications mention of steel to argue your patent effectively covers steel too, without ever having that broader scope examined.
I see. The court wanted to prevent that backdoor broadening.
Precisely. They said if you know about it and disclose it as working, you have an obligation to claim it up front if you want exclusivity. By mentioning steel but only claiming aluminum, Johnston essentially announced to the public, we're taking aluminum, but steel is available for you.
So, dedication. And to make this stick, they had to deal with that conflicting YBM Magnex case, right?
They did. They explicitly overruled YBM Magnex to the extent it suggested anything less than this clear dedication rule. They said the rule is, and really always should have been, clear. Disclosed but unclaimed equals dedicated.
What older cases did they lean on for this? Any Supreme Court guidance?
Yeah, they grounded it in fundamental patent law principles, citing Supreme Court cases like Edo Manufacturing and Mon v. Harwood, which consistently emphasize that the claims define the patent's scope and anything not claimed is free for public use.
But what about Graver tank? That's like the cornerstone DOE case from the Supreme Court. Didn't that allow equivalence even when the alternative might have been known? How did they get around Graver tank?
That's a really critical point they had to address. They distinguished Graver tank. In that case, the equivalent material manganese silicate had actually been included in some of the original patent claims.
Oh, okay.
Those claims were later found invalid for being too broad, but the key difference, according to the Johnson court, was the patentee in Graver tank had tried to claim the equivalent.
Intent mattered.
Intent to claim, yes. Johnston, on the other hand, knew about steel, disclosed it, but made a conscious choice not to claim it, opting only for aluminum. That failure to even try to claim the disclosed alternative is what triggered the dedication rule here, distinguishing it from Graver tank.
Got it. Now, you mentioned this was on banc, the full court. Was everyone on board, or were there disagreements?
Oh, definitely not unanimous. This decision sparked some strong feelings, reflected in concurrences and a notable dissent. It really highlighted the philosophical split.
Who dissented, and what was their main beef?
Judge Newman wrote a powerful dissent. She basically argued the majority was creating a harsh, new, absolute bar that actually went against Supreme Court precedent, like Graver tank, in her reading.
Okay.
Her big worry was the practical effect. She predicted inventors would now become afraid to fully disclose alternatives in their specifications for fear of accidentally dedicating them.
So it could stifle the very disclosure the patent system is supposed to encourage.
That was her fear. Less teaching for the public. She also pointed out that Johnston did later file other applications to claim steel, arguing that this negated any intent to dedicate it permanently.
Interesting counterarguments. What about the concurrences? People who agreed with the outcome, but maybe for different reasons?
Right. There were a couple of interesting concurring opinions. Judge Rader agreed RES shouldn't be liable, but he proposed a different framework. Foreseeability bar.
Foreseeability, meaning what?
His idea was that the doctrine of equivalence should really only be available for variations that were unforeseeable when the patent was written. Think like totally new technology emerging years later.
Okay.
But since Johnston actually wrote down steel in the patent, its use as an alternative was clearly foreseeable. Therefore, Johnston had the obligation to claim it explicitly, and failing to do so meant no DOE protection.
That sounds logical, maybe, but potentially complicated.
Exactly what Judge Laurie thought. He wrote a separate concurrence, agreeing with the result, no infringement, but pushing back against Rader's foreseeability test.
Why?
Laurie argued that figuring out what was foreseeable years after the fact would be a practical nightmare. It would require complex evidence, expert testimony, maybe get tangled up with obviousness analyses. It would just add another layer of uncertainty and litigation cost.
So he preferred the clear, bright line rule.
Yeah. Laurie essentially said the majority's dedication rule, disclosed but not claimed as dedicated, is cleaner, more objective, and easier to apply. Did you write it down as an alternative? Yes. Did you claim it? No. Okay, public. Simple.
So, pulling back, what's the big legal significance here? For patent lawyers, for inventors, what did Johnson Johnston really change?
It provided clarity, albeit perhaps harsh clarity for some patentees. It established a strong, objective dedication rule that significantly limits the doctrine of equivalence when the patent itself discloses the alternative.
Certainty over flexibility.
Pretty much. It reinforced that claims, and only claims, define the legal scope. The specification doesn't act as a fallback to cover things you knew about but didn't claim. It really put the onus on careful, comprehensive claiming during patent drafting.
Did the court leave Johnston completely without options, though? Like if they realized their mistake later?
No, the court pointed out existing mechanisms. A patentee can file for reissue within 2 years to correct claim scope errors. Or they can file continuation applications to pursue claims on disclosed but previously unclaimed subject matter, which Johnston actually did later on.
Ah, so they did eventually get patents claiming steel.
Yes, they secured later patents, the 596 and 937, that explicitly claimed steel and stainless steel substrates. But the specific patent asserted against RES in this case, the 050, simply didn't cover steel because of the dedication. Timing mattered.
Okay, so if you had to distill this whole complex case down to one single most important key takeaway for anyone dealing with patents, what would it be?
It's crystal clear. If you disclose it, claim it. If you mention a substance, a structure, a method as a workable alternative in your patent specification, you absolutely must include it in your claims if you want to maintain exclusive rights to it. Otherwise, you've dedicated it to the public, period.
Disclose it, claim it, or lose it.
That's the mantra after Johnson Johnston.
Here's where it gets really interesting, though, as a final thought to leave folks with. This whole decision hinges on the idea of disclosed foreseeable alternatives, right? Things the inventor wrote down.
Yes, absolutely. The dedication rule applies to what's in the specification.
But it kind of leaves open that question Judge Rader touched on. What about truly unforeseeable developments? Technologies that pop up years later that couldn't possibly have been described or maybe even conceived of when the patent was filed, but might function equivalently.
Right.
Is the doctrine of equivalence completely off the table for those after arising technologies because of this case? Or does the logic of Johnson, the dedication rule, only bite when the alternative was literally staring you in the face from your own patent document? That's still a live area, isn't it?
It absolutely is. This case settled the disclosed but unclaimed issue, but the boundary for truly unforeseeable equivalence, that's a whole other deep dive.
Thanks for tuning in to the full episode. If there's any topic or case law you'd like us to cover next, share your suggestion in the comments on our latest video. And if you found value in the podcast, don't forget to like, subscribe, and hit the bell icon to stay updated.